For those that have joined us already, welcome. We're just going to wait a couple more minutes just to allow others to join us, and then we'll make a start. Okay, good afternoon and welcome everybody. So welcome to this week's Wednesday webinar. Birkett Long is offering a series of weekly webinars on a range of different subjects for individuals, families and businesses. My name is Kaur Johnson. I'm a family lawyer at Birkett Long, and I'm going to be joined in a moment by my colleague Muntech Kaur, who is also a family specialist in a little bit. This week, we are looking at COVID-19, a quick guide to co-parenting. We will be taking questions at the end, so please do make use of the question and answer facility in this app. Muntech, over to you.
Thank you, Karen. Thank you to those that have joined us this afternoon. My name is, of course, Muntech, and I'll just be talking you through some issues concerning child disputes. Now, when we look at the law of disputes concerning children, you'll find the guidance and the legislation for that in the Children Act 1989. Now, in 2014, there were some updates changing some of the terminology, standardising things. So, for example, some of the terminology that was changed from contact and residence orders to child arrangements, live with and spend time with orders. There was also standardising of wording of court orders, standardising of types of hearings, and also the prerequisite of mediation before making an application. However, the essence of the Children Act 1989 still remains the same in most, with the three principles being the welfare of a child being paramount, the court not necessarily intervening unless it has to, and that any application which the court has to deal with should be dealt with as swiftly as possible. And therefore the court's approach remains that it prefers parents to reach an agreement in relation to disputes concerning their children. Now, in terms of who can make applications to the court, these are generally parents, biological parents, who have parental responsibility. There are instances where other individuals, so for example, fathers that are unmarried and not on a child's birth certificate, or even grandparents, can make applications to the court, and those applications are predominantly child arrangements orders to live with and spend time with, prohibitive steps orders, and specific issue orders. Now, when the court looks at an application, it has to consider what is in the best interest of a child. Sorry, Jenny, can I ask you to just turn the slide? Thank you. And so, sorry, Jenny, one back, I believe. Thank you. So when a court is making a decision relating to a child, it has to consider what is in the best interest of a child. There's a presumption that there should be a continued parental involvement of parents in a child's life, unless there is very good reason not to, or unless there are issues of risk which the court needs to explore. Of course, there's also an expectation on both parents that they both work together to promote the relationship to the child of the other parent. Jenny, can you please turn the slide? Thank you. Now, when the court is faced with an application, it has to look at a number of factors before it makes its decision. And that list of factors is referred to as the welfare checklist. Now, what you see on screen are some of the factors, but not all of the factors that the court looks at when making a decision in relation to a child. Now, I'm just going to go through these really briefly with you. So a child's wishes and feelings, depending upon their age and understanding. Of course, the older a child is, the more weight is attached to their wishes and feelings. The younger a child is, the less weight is attached. So, for example, a 5-year-old that says, I want to live with mummy and daddy, you know, will have less weight attached to perhaps a 13-year-old saying that he or she prefers to live with one parent over the other. When we're looking at a child's needs, those needs are not only physical, but they're also educational, and of course in today's lockdown, emotional needs. And the court looks at how capable each parent is meeting those needs, and of course what support network they may have. Now, turning to the risk of harm, this is not necessarily physical harm, but it can be other forms of harm, for example, psychological harm. And bear in mind that for some children, they experience or witness high degrees of parental conflict. What the last factor on this slide is a change of circumstances, and this could be living from one parent going to the other, a change in circumstances in terms of their living arrangements. But let's bear in mind that obviously the first change for a child experiencing a breakdown of family is that they've gone from one household where they are living with both their parents to a household where perhaps they are spending time with their parents individually or spending most of their time in one household instead. Now, some key points to remember about the welfare checklist is that the welfare checklist is in no particular order. One particular factor does not hold any more weight over the other, and the exercise is more holistic, more global when we look at it. And whilst a child's wishes and feelings can be taken into account, as I said earlier, the older a child is, the more weight is attached. Of course, the younger a child is, it's for the adults in their lives to make those decisions for them. When we are looking at a child who perhaps is expressing a particular objection to seeing their non-resident parent, if I can put it that way, the court is of course duty bound to explore why that is. And in most cases, children feel some form of loyalty to one parent or the other, or to their main caregiver, which may colour their views and their feelings about spending time with their non-resident parent. But of course, those are issues for the court to explore if we are in court proceedings, either by asking the parties to file statements or asking CAFCAS to prepare a fuller report about the issues. Now, what are normal arrangements for children after separation? Well, there is not one key that fits all. Every family is different. What may work for one family may not work for another. And you know, there are things, for example, you know, if a parent works, what their shift pattern is, how much annual leave they're entitled to. We may be looking at their support network. We may be looking at, for example, blended families where there are other children that need to be taken into consideration when we're looking at what child arrangements are going to fit a particular family. However, what I would probably define as normal arrangements would be something which is consistent and regular, so that a child is not left not knowing when they may or may not see their other parent, or where arrangements can be changed by the parents at a whim. So what is co-parenting? And as you'll see, the reference to a celebrity and their decision to consciously uncouple, or in layman's terms, deciding to separate, Obviously, the focus here is that they have both tried to co-parent, and hence the term of co-parenting, which simply means working together for the benefit of your child. Now, good parenting, there's a number of characteristics that can categorize what good parenting is, and one of the keys is communication, and obviously good and effective communication which is short, concise, lacks emotion, and isn't done out of the heat of the moment. And this is one of the things that parents find most difficult. Whilst parents can communicate with one another, sometimes things can be taken out of context. For example, in text messages or WhatsApp messages, there are sometimes times when it's misinterpreted, and then that creates a conflict. There are some tools out there that assist parents in better communication. So there are a number of parenting courses that parents can attend if they choose to do so. Most are likely to be paid. CAFCAS also have a separated parents information programme, which is a one-day course. Parents don't have to attend together, they can attend individually, but again, that is designed to assist the parents in better communication. There is also, if you're in court proceedings, a positive co-parenting programme, which CAFCAS offers, which is a 12-week course. But again, that is court directed, and you have to be in court proceedings to be eligible for that. Otherwise, there are other tools. For example, there is our Family Wizard app, which you can find online, and that has a number of characteristics and platforms in which to assist parents. So, for example, it has a shared calendar so that parents know where children are at any given time. There's a message board which assists parents in better communicating, so it's almost like a emotion blocker, or something that, for example, if a parent starts to write something which may sound inflammatory or highly emotional, it will say, well, actually or it may change some of the text for you to make sure that it's as neutral as possible. There's also an expenses log and an information bank. However, the Family Wizard is a service which is payable, and it has a subscription. There are also other tools. So, for example, Resolution, which is an organisation committed to the resolution of disputes in a constructive and non-confrontational manner, and both Karen and I are members of Resolution. They have a number of helpful tools on their website. So, for example, there is a tab which relates to dealing with or managing difficult relationships. There's also a children's charter, which I think is quite a good idea for parents to have a look at and focus what is in the best interests of the children, and for them to come up together a charter, themselves, and one that may suit their family. Thank you, Jenny. And so with co-parenting, obviously, it's not necessary that your parenting style is the same. There'll be different styles because every relationship has different personalities in them. Co-parenting doesn't necessarily mean that a child's time is split 50-50. It can be any makeup, the parents agree, well, that's best going to suit the child. Of course, it's not necessary that you agree on everything. At times there are going to be issues that you don't agree with, and in that case you then implore your effective and open communication with one another about how you go about resolving things, and whether it's something that you can talk through together and come to a resolution, or whether you need to explore other avenues, for example, mediation, alternative dispute resolution, or ultimately you need to consider whether one or the other needs to apply to the court. Of course, co-parenting doesn't mean that you go away on holiday together, but of course, if you want to, and that is a matter entirely for you. Thank you. I will pass you back now to Karen.
Thank you, Muntech. So we thought that it would be really helpful to give you perhaps our top tips when it comes to parenting after parting. The first top tip that I would have is, I've called it emotional awareness. You might call it mindfulness. No one is going to say that co-parenting is easy. It isn't. Even Gwyneth Paltrow was stated to say that it has been really, really hard at times since she separated. A lot of that ties in with the fact that the end of a relationship is often fraught with huge difficulty. It is a highly emotional time, understandably, and those emotions do impact upon our ability to function. I've heard it said that, as it says here, divorce and separation can feel worse than death. No one goes into a relationship expecting it to fail, and when it does, you're regularly going to see your ex-partner, particularly if you've got children together, and you're going to be constantly reminded about the loss of the relationship. There are various things that look into emotions that arise on bereavement and on the loss of a relationship, and the bereavement process is very similar in both situations. You will go through denial, anger, bargaining, depression, and acceptance. Jenny, can you move on to the next slide, please? So when we're looking at bereavement cycles and our emotions following the breakdown of a relationship, some might consider or hope that the emotional recovery is much like what we have heard in the press, the government talking about in terms of their hopes for our economic recovery. A deep V or a deep U, so you have this drop and then an immediate bounce back. Unfortunately, when it comes to grieving the loss of a relationship, it isn't like that. And actually what we've got in front of you here is a chart, and if you like, the different levels going up represent different emotions, and as you go along, that's time. What we've got instead of this deep V is a squiggly line as you move between all of these different emotions. You may start with anger, go on to denial, and then depression. You may then go back up to anger again, and then despair. To make matters worse, it is unlikely that you and your ex-partner are going to be in the same place. When a relationship breaks down, very often one of you will have been the one that will have made the decision that you want to separate. And before you get to the point of making it clear that that is what you want to do, you will have already started going through those bereavement cycles. Whereas your partner, once they are told that you want to separate, will only be starting that journey. Unfortunately, because these issues do have an impact upon our ability to make decisions and the way that we react, we can find that often children are caught in the middle of this, although it isn't always the reason for parental dispute. Acknowledging where you are in this and where your partner is in this means that you can get a better understanding as to where your partner may be coming from and what the reasons for the dispute might be. Jenny, can you move on to the next slide, please? So again, we have some examples there. When we're angry or feeling hurt, we might want to lash out with our words or actions and cause hurt to the person that we blame for the way we're feeling. If we're depressed, we might question each and every decision and those of everyone around us. And again, right, our next top tip is communication. Muntech has obviously spoken about this already, but it's here again because we cannot stress enough the importance of effective communication. It is absolutely key. It needs to be effective communication, and this does mean that it does need to focus on what needs to be said. Very often when we are involved, we will see communication between the parents individually that goes far beyond what is absolutely necessary. The main points that need to be said are often lost in a ramble of words and sometimes inflammatory or hostile phrases. Sorry, Jen, can you go back slightly? Unless it's an emergency, one good tip is to sleep on what it is that you're going to say. Draft an email and then pop it to one side and then really think about it. Come back to it, look at it with a fresh pair of eyes and consider, do I really need to say that? Am I saying it in the best way I can? Is it likely to simply make things worse? This is something that we do as solicitors. Sometimes we'll be drafting letters and actually we will put them to one side because we think, actually, is that the best way to say something? And it is a really good way of keeping things as constructive and conciliatory as possible. Another key of communication, it's not just about what you say, it is actually making sure that you really listen to what your ex-partner is saying. Try to understand where they are coming from. What are their concerns? How can these be addressed? It can also help your understanding to rephrase what you want to say. Sometimes we find that what we're saying and what we're actually saying and what we want are the same things, but we're saying it in different ways. So there may not actually be that much of a dispute as you might otherwise think. Muntech has already mentioned that there are various apps such as Our Family Wizard that are really useful and provide you with additional tools to allow effective communication. Right, another tip that we have is to focus on what is really important. Remember that you have these children together and you both share this common goal. You both want what is good for their health and well-being. Picture how your children might look back on this time in their lives. Your children learn so much from you, and that includes how to resolve conflict, and they are going to take that further forward in their lives, and it is going to impact upon how they deal with conflict in their relationships, not just with romantic ones, but in the workplace and every part of their lives. Your children are also going to have numerous milestones that they will want to share with you in the future. They love both of you and they will want to share those important times with you. That might be birthdays, graduations, weddings, and being parents, you are going to want to be part of those with them. So picture how you want the future to look. Another tip is don't sweat the small stuff. Okay, it is okay not to agree on everything. You are not going to agree on everything, and that is absolutely fine. No two parents are ever the same. No two people are ever the same. Whilst you're together, you will have undertaken very different roles during the relationships. That isn't going to change now that you're separated. So long as there's no safeguarding issues, different parenting styles offer a child a balanced view on the world. You both have an important role to play, and it is really important to remember that. So I'm going to pass you back over to Muntech, who's going to have a little bit more to say about the impact of COVID-19.
Thank you, Karen. So early into 2020, we all became aware of COVID-19. The date of the 23rd of March is etched in everyone's memory as being the day lockdown was imposed. Now, the lockdown and COVID-19 have impacted upon every aspect of our lives, our work lives, our personal lives, our interactions, as well as arrangements that relate to children. Now, there is still no cure for COVID-19. It continues to be a highly contagious virus. And the government is trying to do its best to manage the virus and ensure that our NHS and other medical services aren't overrun. Having said that, obviously the death toll as of yesterday was still some 51,766, and that is still a significant number. And so in terms of, Jenny, so can I have the next slide, please? Thank you. So in terms of the changes that we have all faced, our whole lives have been thrown into disarray, schools have been shut, our places of work have been restricted, people have been given instructions, certainly the vulnerable have been given instructions to shield themselves for a period of 12 weeks. We have to engage in social distancing from our relatives and our loved ones. We have to wash our hands while singing happy birthday. We have to stay at home, and obviously now that some of the restrictions are, some of them are removed, some of them are relaxed, but they're still pretty much, we will stay at home until I suppose there is a virus, or we can manage it as best as we can at this stage. And so Jenny, can I have the next slide, please? So if we are looking at arrangements where, for example, a parent or a child has to self-isolate or quarantine, obviously the symptoms are already well published, and the guidance from the government is if you or if anyone in your household, or if you're contacted by NHS track and trace of having been exposed, having symptoms, then you must self-isolate for 14 days. Now, having said that, obviously in some families this can prove difficult because there are child arrangements that will be disrupted, and it's down to parents to be open and honest in their communication with one another in terms of if a child or if a parent is suffering from COVID-19 symptoms and have to self-isolate. Let's bear in mind that obviously if a child has been exposed, and where certainly both parents have parental responsibility, that parent that doesn't live in the same household as their child is entitled to know if their child is sick, for example, or has contracted the virus. So let's not forget that aspect of parental responsibility. Now, if like I and many of my colleagues and my relatives, you have been creative about keeping in touch with your colleagues, with each other, with your loved ones, the same applies for children and those parents that don't live in the same household. Be creative. There are lots of social media platforms that are available now that perhaps may not have been available years ago, in which we can still ensure that the relationship between a child and a parent is still promoted. You know, there's WhatsApp, including video calling, there's Skype, FaceTime, Zoom, everyone's become familiar with, and of course the old-fashioned telephone call. Look at what works for you, look at what works for your family, but please ensure that the relationship is continued to be promoted. Now, Jenny, can I have the next slide, please? Thank you. Now, if your child or you are in the vulnerable category, and there are periods of self-isolation, of course, follow the government guidelines. However, when lockdown first came into place, there was some concern of the disruption that was going to take place to child arrangements. And on the 23rd of March, the government was very clear in its message that said that whilst there was lockdown, the exception to the lockdown was that children that travel between two households for the purposes of child arrangements, and those arrangements would continue. Then the following day, on the 24th, the president of the Family Division, Andrew McFarlane, also issued clear guidelines saying that if there's a child arrangements order, for example, there's an order in place which says that one parent must make the child available to spend time with the other parent, that should be complied with, of course, providing that it was safe to do so. Now, bear in mind, with child arrangements orders, those carry repercussions or penalties if you don't follow it. Every child arrangements order to spend time with has what we call an automatic warning notice to it, which effectively acts as the court's teeth, the court order's teeth, and the aggrieved parent can make an application to the court to enforce that if necessary. But obviously the exception being obviously if you are in that high risk category, again, coming down to the issue of good communication, effective communication, we should be able to work through this. Jenny, can I have the next slide, please? Now, not all arrangements take place at home, or exchange isn't necessary between two households. There are some arrangements which are currently taking place in contact centres. Now, unfortunately, with the adherence to social distancing, these contact centres are closed and remain closed for the safety of everyone, and it's for individual parents or those families that have the facility of their time in contact centres to contact that particular contact centre to ascertain when those contact centres are likely to open, and what the arrangements are going to be, how many families are going to be permitted, for example, and bear in mind that contact centres are oversubscribed in any event. Be mindful that it may take a little bit of time. Having said that, and going back to my point of being creative, if a contact centre is closed, explore other ways in which a child can still have some form of relationship with the parent that they don't live with or don't live with the majority of the time. You know, we have been creative in other avenues of our life, and so we should be equally creative when it comes to our children and how we promote that relationship with the non-resident parent. Jenny, can I have the next slide, please? Thank you. There are some occasions where handover takes place at school. Schools are closed, so for obviously for key workers, and whilst there's been some lifting of restrictions, if handover at school applies to you, think of alternative venues where you can hand children over to their non-resident parent or to the other parent, and think about this. I mean, you know, most are like public places, so you're talking about Tesco's car park, for example, and there's a reference to a police station. However, my warning about handover at a police station is that any handover venue should be child friendly. And so unless there is a particular reason, unless there is a particular risk to safety, be mindful that you choose a location which is child friendly, because at the end of the day, as Karen said, what do you want your child to remember? And you don't want your child to remember that handover took place at a police station. Jenny, can I have the next slide, please? Now, one of the questions that I've been asked is about child arrangements and what happens given that the most children are still off school, and does that entitle the parent with whom the child does not live with full time to have more time? Now, unfortunately, the short answer to that is no, it doesn't, because the child arrangements order and the homeschooling doesn't necessarily apply in the same way as it may apply to, for example, school holidays. However, having said that, we are in unprecedented times, and we should perhaps look at the issue in a child-focused or a child-centric exercise. Think about, for example, those that are working at home. Think about whether it benefits your child to be in two different households, to have the homeschooling. Think about how the other parent may want to help with homeschooling, or you perhaps may want to say offload, not quite offload, your responsibility and perhaps have some respite yourself, or maybe just be able to work from home in peace and quiet. So whilst a court order may not say that obviously when we are in periods of lockdown, that the non-resident parent not have more time, every child arrangements order has an additional provision of any further or additional time as parents may agree. And so this is the time for you to both work together, work on those communication skills, and see what you can do for the betterment of your child and what is in your child's best interest, rather than perhaps considering, do we need to adhere to the letter of this particular order and the child stays at home, or with their resident parent or their full-time carer more times than being in the care of the other parent. Jenny, can I have the next slide, please? Now, for some children, school has been open. For those that are key workers or frontline workers, those children are still going to school. The government did issue further guidance in terms of the return of children to school, including year 1, year 6, year 12 and year 10, and some reception children. Now, yesterday the government has slightly backtracked in that where they anticipated this all primary school children would be returning to school soon. The guidance is now that most primary school children are likely to go back to school in September at the very earliest. And so when we are looking at returning the children to school, obviously parents are concerned over the risk to health as well as the loss of education, and those things of course need to be balanced with one another. And again, this is where your effective communication kicks in, and both parents should communicate with one another in terms of how they wish to approach the issue and whether a child should be going back to school now or whether you wait until September. Jenny, can I have the next slide, please? Thank you. So not in all occasions are parents going to be able to agree this issue. If your concerns are in relation to, for example, how the school deals with social distancing or policing social distancing, for example, then speak to the school. And what I would stress is that both parents speak to the school, not just one. And if you have any particular concerns, at least these can be part alleviated or they can be dealt with. Of course, speak to one another. And communication is really the key. I cannot emphasize that strong enough. Adopt a common sense approach. Think of this as a child-focused exercise, and where, of course, you can't agree, think of other avenues that you may want to explore. For example, mediation, alternative dispute resolution. A lot of mediators at the moment are doing mediation sessions remotely, so that should alleviate some of the problems and the delays. But bear in mind, for example, if your dispute or your issue with the other parent does relate to return of children to school, and whether that should be now or then, let's bear in mind that obviously the school term ends on the 17th of July, and therefore we're talking about another 5 weeks, and really think, do I really want to make a court application? And let's bear in mind, obviously the court should always be your last resort as opposed to your first. And so having said that, I will hand you back over to Karen.
Thank you, Muntech. So there are going to be things that you don't agree, and they're not always going to be small things, and there may sometimes be something that actually does need to be decided, preferably agreed still, but you may need a little bit of help. So if you don't agree, yes, an application can be made to the court, but it should always be a last resort. As we mentioned at the beginning, the court's preference is for parents to be able to reach an agreement between themselves. Unless it is an absolute emergency, it is usually expected for there to be at least some attempt to resolve matters outside of the court by way of negotiation. Okay. With regards to that, it does mean that anyone wanting to make an application to the court has to at least attend something called a MIAM. That stands for Mediation, Information and Assessment Meeting. Now, the alternatives to the court process are negotiation between yourselves, negotiation through solicitors, mediation. Okay, and mediation works on the basis that both yourself and your ex-partner would have meetings with a mediator. The mediator is independent and impartial and is there to facilitate the discussions between you both. The mediator can't give you legal advice, but can give you information. But solicitors can give you advice if you need it. So what you might decide to do is to try mediation, but where you feel that you need a little bit of advice alongside it, you can come to us to get that. There are also options of collaborative law, where you both instruct solicitors who are collaboratively trained and they will assist you in your negotiations, with you all agreeing to resolve it outside of the court process. Now, if you need to make an application to the court, as I've mentioned, you need to attend a MIAM. Now, most mediation services are offering these on a remote basis. Okay, if you need to make an application, you're encouraged to use an online application process. Urgent applications concerning the children are considered to be priority work. Standard applications regarding children, whilst not priority, are still considered to be important work that will be done, at least insofar as the initial stages. Now, in relation to this, we have actually just had some updated guidance, which was published by the President of the Family Law Division, and this relates to hearings going forwards. Now, unfortunately, we are warned that the courts are not likely to be back to normal before the end of 2020, and it may even be spring 2021. Now, as a result of the pandemic, the courts have had to move very quickly to ensure that the family courts were able to continue to operate in a way which continued to provide access to justice. This was a very steep learning curve, and there were regional variations in terms of how effective the courts could be. There were issues with technology and concerns were raised as to fairness. It was quickly apparent that not all cases were ideal for remote hearings, and these would be adjourned in the hope that courts would very quickly return back to normal. As this new guidance makes it clear that we cannot expect to be back to normal anytime soon, we've got to look to see what we can do instead. Now, at this point in time, hearings are continuing to take place. The majority of those cases up until now have been heard remotely, and that's been either by way of video link or telephone conference where appropriate. Not all cases are suitable to be heard remotely, and because the court only has capacity to deal with around 40% of its usual caseload, we know some hearings are being adjourned, and again they're being adjourned because not all is suitable. Now, the guidance released yesterday tells us that the level of applications to the court has remained consistent with the levels before the pandemic. The difficulty that we have with that is that the courts were struggling with the workload prior to the pandemic. What we're dealing with now has simply severely exacerbated that problem. If we continue to adjourn the cases, that is going to add to it further. Now, when we deal with children cases, the court is obliged, when considering management of cases, to keep in mind the prejudice that delay will cause to a child. It is, in other words, beneficial for a child to have matters resolved as soon as possible. The new guidance makes it clear that when managing cases and considering what provision to put in place for hearing matters, the court has got to take into account that prejudice that would be caused by a delay and weigh that up against everything else and considering how the matter can be dealt with fairly. I think that moving forwards, we are going to see an increased number of courts reopening and able to operate hearings subject to social distancing. This is a hugely positive step, but it is important to appreciate that we are still going to be far from normal. There are going to be limited suitable courtrooms, and there will have to be strict limits in place on the number of people attending court. We are, however, also told in the guidance that we can anticipate moving from predominantly remote hearings to a situation where some, and hopefully on an increasing basis, are heard either fully attended within the courts or being part attended, part remote, so more of a hybrid. Now, when the court is considering which type of hearing to put in place, the guidance suggests that telephone hearings are to be considered the most remote. I think we are going to continue to see those hearings put in place for short case management or directions hearings. So those are hearings that are simply dealing with the mechanics, ordering one party or another to prepare a statement, for example, or to set out the next steps. Anything more substantive, so I think if there is an issue to be determined that requires the court to hear evidence, then those will be considered on a case-by-case basis in order for the court to consider what is the most effective and fair way to deal with things. Because the court time is going to be limited, the guidance also warns us that we can expect more robust case management. Now, this is already something that the court can do and does do, but I think we should expect it to a greater degree. Now, what that is going to mean in practice is that hearings will only deal with what is absolutely necessary to decide the case. We are warned that people cannot expect to litigate every single issue, and they will need to focus on what is really important. Where the court has got to decide an issue, the guidance also suggests that the court consider whether or not it is necessary for there to be a hearing. The way I read that is that I think we are going to see an increase in hearings where parties are represented, with those issues being decided on the basis of written submission. So this is where the barristers or solicitors set out the arguments that they want to make to the court and for the judge to take into account when they make the decision, but there will be no live evidence, no live hearing. Now, the other thing to bear in mind with all of these difficulties is that there is another alternative to making an application to the court, and that is called family arbitration. Now, family arbitration is something that you both have to agree to. It works on the basis that you both agree to appoint somebody who is qualified to act as a decision maker. These people are often family solicitors, barristers, or even judges. You do have to pay for their services, but the process is often quicker and more flexible than going through the courts. Now, if you are looking at a remote hearing, so say, for example, you've got a remote hearing listed, what can you expect? Jen, can you move over to the next slide, please? Oh, and the next one. Okay, so if you have a hearing listed, you will need to check to see how the court wants that to be dealt with. Now, when a hearing is listed, you will receive a hearing notice. That should set out in that notice whether the hearing is going to be taking place remotely and whether it will be by telephone or video. Okay, we do still have cases coming through where we have hearings that were listed prior to lockdown where it is not clear. In those cases and in cases where the notice says that it is to be a remote hearing, we should be expecting contact from the court at least 3 days beforehand to confirm the arrangements for the hearing. Okay. In this respect, it is really important that you ensure that your solicitors and the court have your current contact details, because they are the ones that will be used to set this up. Now, before the hearing, some important things to do to prepare. So you need to decide where you're going to sit. It should be a space that is quiet and private. Let people that live in your household know that you must not be interrupted. Make sure that the device you're going to be using, whether it's your telephone, laptop, iPad, whatever, is fully charged and plugged in so you don't get cut off. Make sure you've got any documents ready and to hand. Turn off your mobile phone, assuming you're not having a phone call, and anything else that could be distracting you. So don't have music playing in the background, don't have the telly going, for example. And we would also say be ready at least 15 minutes beforehand. Now, if you are going to be represented at that hearing by a solicitor or a barrister, it is a really good idea to agree with your barrister or solicitor a way of communicating with them outside of the court telephone system or video conference facility, because you are going to want to be able to speak confidentially. And the way that our barristers, and we've been dealing with this, is using WhatsApp, email and text messages. Now, if you are going to be joining a video conference, check that you have the right software for your device. Okay. Now, the courts have until now been using a wide variety of software to join video conferences. There have been instances of them using Zoom, although this isn't supported by all judicial laptops and computers. It seems that most have got access to Teams, and most seem to have access to Skype for Business. There is also now something called the Cloud Video Platform, which they're rolling out across the country, and is another platform that they'll be able to use. The way I understand it is most operate in a similar way to the way in which you've joined this meeting. So there will be a link for you to click on, which will allow you to join. So it should be fairly straightforward. It is, of course, a good idea to test the equipment so you know it works beforehand. And if you're going to be appearing on a video, make sure that you dress as if you were coming into a court building and treat it as if it were a hearing. Try and make sure that you've got something plain behind you. Some apps such as Teams do have backgrounds that you can use if finding somewhere plain is going to be difficult. Sit with the light in front of you so that your face can be clearly seen, and make sure that people can see your face and shoulders. Now, during the hearing, you can expect the hearing to take the same format as it would if you were in the court building. The judge will explain it to start with what's going to happen. A judge might ask you questions to make sure that you've understood. If you don't understand something and you're not sure, say so. There's no harm in doing that, and it is far better that you understand what is being asked of you and you answer correctly than try and answer a question that you don't really get. Now, because during hearings there will be numerous people taking part, it can get really confusing if everybody's got their microphone open, because you can end up talking over each other. So try and mute your microphone if you can, so that you and everyone else can hear what is being said. When your video is on, obviously make sure that you do mind your body language and your behaviour, whether you're speaking or not, because you will be seen at all points. Again, treat it as if you were in a physical courtroom. Now, there are some rules. Now, the rules are, during your hearing, you should only drink water. There's no eating, no smoking or e-cigarettes, and you should follow any instructions that you're given. You also need to be alone unless you're given permission otherwise. Okay. If you are feeling quite vulnerable or anxious, when we're in the court building, sometimes we can ask for court's permission to have somebody come into the courtroom with you. It's more of an exception than a rule, so it doesn't happen particularly frequently. And again, if you do want somebody with you, you need to ask for permission, and that is the same whether or not it is video or telephone. Another thing to bear in mind is you cannot record what is going on. It is a criminal offence to do that without the court's permission. Right, so before we take some questions, just to let you know, we're going to be sending a recording round to everyone that signed up for today's webinar, and that's going to come out to you all tomorrow morning. We're also going to include with that a link to a very short survey. We would really appreciate it if you could complete that, so we can make sure that our future webinars are helpful to you. Now, as I said at the beginning, this is one of a series of Wednesday webinars. Next week's session will cover looking after a loved one's affairs. So if that is of interest to you or of interest to someone else that you know, then please visit our website, get them to visit our website or go on to Eventbrite and sign up. So now we'll be taking some questions.
Thank you, Karen. I think we have one question. Who is responsible for organising remote hearings if both parties do not have legal representation?
Do you want to answer that, Karen, since you covered the topic?
Okay, so if neither party is represented, it is generally going to come down to the court to organise it. As I mentioned, what will generally happen is at least 3 days, hopefully, before the hearing, the court will make contact with you and will want to have your telephone numbers or email addresses so that they can set these things up. Hopefully that answers the question.
Sorry, can I just add to that? If you don't have legal representation, I always think it's best for someone to be proactive. Yes, it is down to the court to contact the parties so that arrangements can be made, but even myself as a solicitor have been experiencing difficulties with the court where you're waiting for communication. You can contact the court on their switchboard number. There's also an email address, so do be proactive about it, because the last thing you want is that where a remote hearing was going to be possible to progress matters is that either yourself or the other party don't attend or weren't aware of any of the details, and then it makes it an ineffective hearing, and then that simply adds to more delay in your matter unnecessarily. So be proactive yourselves. Just chase up the court. The court is incredibly busy. The court staff are probably working very, very hard. However, these things were important to you, and certainly to progress your matters and to progress to a resolution or a determination ultimately. So please be proactive yourselves. Thank you.
Thank you, Muntech. Due to timing, what we'll do is we'll any other questions that come in, we'll get the speakers to reply directly. Thank you.
Okay, thank you all for joining us today. We will review any questions that have not been answered, and we'll come back to you. And of course, if you find that you've got any questions at any time, we'd much rather that you give us a call. We do offer an initial free chat, and up on your screen there are our direct lines. So again, give us a call and we can sort something out. Thank you.